God's sakes. All right. Well, I'm trying to figure out how to get me on my own show. Let's see if I can make that work. There we go. Welcome, everybody. All right. Well, I'm trying to figure out. Welcome, everybody, to the Law of Self-Defense Show for, what is today? Wednesday, March 23rd, 2022. Welcome, folks. Welcome, everybody. Let me see what I need to pull up here in terms of the chats and comments. We have a ton to cover today. I apologize to all of you in the Law of Self-Defense community. It's not booze, folks. It's just Topo Chico, little seltzer water to start. I apologize to all of you in the Law of Self-Defense community for the sporadic content delivery the last week or so. Of course, before then, I was in Texas, hence the animal sitting on the lower half of my face. And then after that, frankly, it's just been, it's always tough catching up on everything, catching up on client work. Something I want to touch on again, folks. I get back from my trip to Texas and I have letters, like real letters, and they're real letters waiting for me because they're written from people in prison. These are people in prison who are desperate for help on their self-defense case. And invariably, the bottom line message in these letters, whether explicit or implicit, is these people wish that they knew then what they know now about self-defense law. And it's just too late for me to help them now. Don't be one of these people, folks. Know the law of self-defense before you're compelled to defend yourself and family, before you establish the facts that your lawyer is going to have to argue in front of a judge, in front of a jury, in front of a prosecutor about your use of self-defense. To contact me after the fact, there's a limited amount to do I can help for you, folks. Even the best lawyer in the world is stuck with the facts that you give us. So please do not be one of these poor people. All right. Well, on that happy note, welcome to the Law of Self-Defense Show for March 23rd, 2020. Oh, Brian just got his book delivered. Thank you very much. We have a ton of stuff to cover because every day I aspire to delivering. Let me try to fix this camera a little bit. I'm throwing myself off here. Try to deliver 20 or 30 minutes of content, a regular, well, drip seems an inappropriate term, but a regular flow of content. That's even worse, I guess. Regular content every day, a bit every day. But sometimes I just get too busy with letters like that, with client work and the news, the information I'm able, outside of client confidentiality, to share with you. I have to just accumulates. And so it backs up until the point where I did finally find perhaps an hour or two today where I can dig out from that backlog of content I wanted to share with all of you. Address whatever questions you have. By the way, if you are on, this should be streaming to both live on both the Law of Self-Defense YouTube channel, as well as on the Law of Self-Defense membership page. That the YouTube channel I've pretty much got under control in terms of reliability of streaming. Unfortunately, the Law of Self-Defense membership page is proving a little more difficult for this boomer to deliver content to, live content to, on a in real time. Let me take a look here myself, getting that all to work. And yeah, it's working. Hey, LOSD members, awesome. So, wait, maybe I have in fact figured it out. So I will answer as many questions as humanly possible about the various use of force cases I'll cover today. Any questions you have outside the use of force cases covered today, that's all I do is answer use of force law questions. But we have so many comments in, first of all, if you're a Law of Self-Defense member, post your question on your member dashboard where this video is also playing live. You guys obviously get priority over everybody else. So I will answer all your questions. If you're on our YouTube channel watching this, thank you. Please, if you can, hit that subscribe button. We're this close. We're a few dozen people away from 30,000 subscribers. And you need to subscribe to comment. So it's free, folks. I mean, it doesn't cost you anything. hit that subscribe button, please. Hit the like button if you can. If you comment, even if it's just with your city and state, first of all, that can inform my commentary because use of force law does differ by state. But if nothing else, it tricks the algorithm into making more people aware of the law of self-defense content. Yeah, still bearded. My wife still won't let me shave off the beard. So I'm debating whether I should do some kind of special live show where I actually go unbearded, not unbreaded, unbearded live for your shaving pleasure, I guess. We'll have to see. I'll have to figure out a way to make that worthwhile. But yes, still have the beard. So I'm happy to answer your questions. If you pose them on YouTube, perfectly happy to do that. But we get so many comments, folks, hundreds and hundreds of them. I can't possibly answer all of those. So you do need to put it in super chat form on YouTube. If you're a law self-defense member, just ask on the member dashboard. And by the way, you can become a law self-defense member at lawselfdefense.com/join. It's about $0.25 a day to be a law self-defense member, not a lot of money. And we will always absolutely answer your questions. If you're not a member and you're on YouTube, I'll do my very best, but you need to put it in a super chat format. Otherwise, there's only so many hours in the day, folks. And for those of you who follow me on Instagram, by the way, folks, we're on all the social media platforms. So we're on YouTube, Facebook, although I don't do much on Facebook anymore, Instagram, Rumble, Locals, pretty much anyone you can think of. And we have little shortcut URLs to each of those. So whichever one you use, you can just point your browser to lawofselfdefense.com/whatever the social media platform is, and you'll find us. So lawofselfdefense.com/Instagram will get you to our Instagram page. Lawofselfdefense.com/locals will get you to our locals page, and so forth. So that's the easiest way to find us on whatever social media platforms you prefer. And if you have been following me on Instagram, you might be aware that I have begun yet another fitness regimen. For those of you who've been members of the law self-defense community for any time, you know that pretty much from October through March, well, at least through February, I was following trials as they occurred in real time, sitting here at my desk for something like 8 or 9 hours a day, then spending another 2 or 3 hours a day producing commentary, video, written audio for our podcast on those trials. And those are long damn days, folks. Those are 15-hour plus days. And then there's barely time to sleep and do it all again the next day. So you won't be surprised to hear I gained like 20 something pounds during that multi-month process of following all those trials. So the high profile trials, the self-defense trials anyway, are in a pause at the moment. I'm sure they'll start again. Americans love to shoot each other, so I'm sure there'll be another high-profile use of force case coming up real soon. But in the meantime, there's a pause, and so I'm on another weight loss regimen. It's a regimen that works for me, so I can't say it's a struggle in the sense of I don't know what to do. I know absolutely what to do, or at least I know what's worked for me in the past. It's a struggle to do it. I mean, I hate it. I hate the process. But for me, that involves, for those who are curious, first of all, I'm 57 years old. A little over a week ago, I started this at 222 pounds. Yesterday, I was 215. So in a week, I lost about 7 pounds. And that's pretty typical weight loss for me on this regimen. It's not an easy regimen, but it's very simple. So for me, because I'm getting a lot of questions about this, it's a combination of intermittent fasting, caloric restriction, and then treadmill work. First walking and gradually increasing the percentage of that that's running. So the intermittent fasting for me is I don't eat in a day until 1 o'clock in the afternoon, which is really just a late lunch. That's not that difficult. It's the only time of the day I get hungry, though, is about 11 o'clock, 12 o'clock. I start getting hungry, but at 1 o'clock I eat, and then I eat very little. So I only eat about between 12 and 1,500 calories until 9 p.m. at night, which is when I go to bed. So I only eat between 1 and 9. I only eat at the most 1,500 calories. And then over the course of the day, I do either 2 or 3 sessions of work on the treadmill. That adds up to about 1,000 calories of burned body mass, I guess. And if I stick to that regimen, I consistently lose, on average, I would say about 3/4 of a pound a day. It's not easy to do. I hate the treadmill. I hate running. I don't much like dieting. It's no fun for sure. And by the way, all of that also requires no alcohol. I know I can hear the screaming come over the internet, but it doesn't work if you drink any alcohol at all, folks. So I figure I need to do this for about a month or so, and that'll get me down to the 190s, which is a more reasonable weight from it. Probably I should be in the 180s. Now it is interesting. Every once in a while, something comes up from work or whatever where you can't stick to that regimen. The next 4 days, by the way, folks, if you don't know, Friday, Saturday, and Sunday are the Tom Gibbons and Lynn Gibbons Tactical Conference. It's down in Dallas. I'll be speaking there, as I do, the last several years at least, and many times before. And it's a fantastic event, and I would encourage you to sign up and go, except like it is every year, it's sold out. So if you're not already signed up, you can't get in. But I would urge you to go to their website and be prepared to sign up as soon as next year is available. This is a fantastic event, world-class trainers, and I don't say that to puff myself up. The other folks who teach there, I sit in their classes because they're amazing. They're unbelievably good, and you get all that instruction consistently in consistently, it's not the word I want, although that's true, in a concentrated form in just 3 days. It's unbelievable. But I speak there Friday morning this week, so I'll be in Dallas at the Dallas Pistol Club where this event is taking place. I'll stay all day Saturday. I fly out Sunday, but I fly there tomorrow. Tomorrow afternoon, I'll fly to Dallas. So for 4 days, roughly, I won't have my normal diet regimen. It'll be interesting as I track my daily weight loss, what happens over that 4-day period. Yeah, and folks, one of the reasons I do the fitness regimen so rigorously is I hate it. And I was always brought up that, if you got a tough job, first of all, you don't have to like the job. You just have to do the job. And if it really sucks, well, get it done first and get it done fast. And then it's over. So that's how I deal with fitness. By the way, I'm not advising anyone else to follow that regimen. I am not a nutritionist. I am not a health guru. I'm not a fitness expert by any stretch of the imagination. Presume I know nothing about all of those. I'm only sharing what works for me, has worked in the past, and is working this time as well. Okay. So what did I want to dive into today? I had a few particular topics, and the one, and hopefully this will wrap up the last time I ever have to talk about this, and that is the case of Kayla Giles. Kayla Giles, the platinum, I believe it was a platinum level, very high level member of USCCA, who found that despite their marketing claims, USCCA, in fact, did not have her back when she was brought to trial for killing her husband or ex-husband, and she was permitted by the court to argue self-defense. USCCA ran out, decided they were not going to support their member in that self-defense trial. And I've written about this extensively. If you go to lawselfdefense.com/USCCA, you'll find many prior blog posts about this. So I don't want to cover this again to death. I'll go over a quick review of the facts here. And the first thing I'll say is that this claim of self-defense by Kayla Giles in the shooting of her husband or ex-husband, I forget if they were divorced or going through the divorce still. The shooting occurred during a custody swap with their children. So the children saw this go down, sadly. But the first thing I'll say is this shooting was sketchy. It's not an obvious case of self-defense. This is not a George Zimmerman case or a Kyle Rittenhouse case where the evidence is overwhelmingly in favor of self-defense. That's not this kind of case. This is a sketchy case. There's good reason to believe that this was not a lawful use of defensive force by Kayla Giles. That's not the question, though. The question is, who gets to decide whether that's the case? That's the question. So in our criminal justice system, if you've used force against another person, you've killed them, let's pretend like here, and you're charged with murder or manslaughter, and you go to trial, before you're not just magically or automatically allowed to argue self-defense. You have to meet what's called your burden of production. You have to produce some minimal amount of evidence, a prima facie case of self-defense, or the judge will tell you to go screw when you want to argue self-defense in the trial. If you just say you forcibly broke into someone's house and you shot them in the head while they were sleeping in their bed, There's no interpretation of those facts that could possibly be self-defense. So a judge is not going to allow you to argue self-defense on those facts. But if there is evidence from which a reasonable jury could conclude self-defense, well, then you've met what's called your burden of production. Now you are allowed to argue self-defense to the jury. The court has said you are allowed. You've met your legal threshold for being permitted to argue self-defense in front of the jury. One take-home lesson for all of us, by the way, folks, is you don't automatically have that privilege, right? As I've just described. So make sure you know enough about use of force law that you don't put yourself in a position, that you don't say things in the aftermath that could put you in a position where the court says you failed to meet your burden of production, and that jury will never hear the words self-defense said in that courtroom. That would be bad, right? Because you've already said you did it. If you didn't say you did it, if you didn't, you're not saying I didn't do it, I was someplace else. You're saying I shot that guy, but it was self-defense. If the court takes self-defense away from you, all that's left effectively is a confession. So that's not a good place to be. So make sure you know enough about use of force law to know what's required for you to meet your burden of production so you can argue self-defense to the jury in the first place. So the court here said Kayla Giles had met her burden of production on self-defense. She was going to be allowed to argue self-defense in front of a jury. It was good enough for the court. Her lawyer was prepared to argue self-defense. Indeed, he did argue self-defense in front of the jury. That was the plan all along. And during the long pre-trial process, Kayla Giles, as her USCCA membership told her to do, and by the way, this is being used against her in the media. The media is saying, well, right after she shot her husband, she called this murder insurance company, USCCA. Well, that's what they taught her to do. The USCCA, if you know, they send you a membership card, says, hey, if something bad happens, call us. Here's our emergency hotline number. That's what they tell you to do. So that's what she did. She called USCCA. Her lawyer got connected with USCCA, her criminal defense attorney, and he said, listen, my client was involved in this event, and she claims it was self-defense. The court's allowing us to argue self-defense. I intend to argue self-defense with the court's permission. That's the argument we'll be making to the jury. She has this $150,000 criminal defense coverage with you folks, USCCA. We'd like to start getting that money. And sure enough, USCCA started sending the money. Initially, they sent $50,000, which was probably the initial retainer demanded by that criminal defense attorney. They sent the $50,000 and some time goes by, and then the lawyer says, all right, well, it's time for more money now for the criminal defense. And by the way, this is all still pre-trial, folks. And USCCA then said, no, we're not going to send any more money. And the lawyer said, well, her coverage is for 150. You've only sent 50. We need more money. We need more money because those are the resources you use. Money is the resource you use to wage a legal battle. It's just like a military, folks. If you don't have the soldiers and the tanks and the planes and the ammo, you're not going to put up much of a fight, right? You need those resources to wage a physical battle in the military sense. Well, you need money to wage a legal battle, an effective legal battle, especially when you're looking at a consequence of the rest of your life in prison. Indeed, that's why people sign up for programs like USCCA, is to make sure they'll have the resources they need to fight that legal battle. Otherwise, what's the point? So she had signed up. Now she expected to have the resources, and USCCA said, nope, we gave you the first 50. That's it. You're not getting any more from us. So the lawyer sued USCCA in federal court. Now, I want to make something clear here. I'm using the moniker USCCA. In fact, there's a constellation of companies, of corporate entities involved here. There's USCCA, there's Delta Defense, there's another insurance entity standing behind Delta Defense. So when I hear, for purposes of our discussion here, I don't want to keep saying 3 or 4 corporate entities' names. It just becomes unwieldy. So when I say USCCA, I mean them and all the other entities involved, each of which may have had different areas of responsibility here. The bottom line is, doesn't matter. And by the way, folks, one of the things they did, it's like having multiple insurance programs at any time. They all pointed the finger at each other. Everybody said, it's not our responsibility. It's not our responsibility. Go after that other person if you want your money for your criminal defense, where you may spend the rest of your life in prison. It was terrible. So in any case, when I say USCCA here, I mean them and all those other corporate entities involved, because I don't really care who the corporate entities are. I care about whether or not this defendant's reasonable expectations of what she was going to receive as a consequence of becoming a USCCA member, were realized or denied. And in fact, they were denied. So the Kayla Giles lawyer sued USCCA and the other corporate entities in federal court. They all filed briefs with the court saying, no, it's not us. You got to go after those other people to get the money. Nobody was giving up the money. And essentially, the civil case was put on pause to give priority to the criminal case, because she was charged with, I believe it was murder for the killing of her husband. In Louisiana, she was being brought to trial criminally for that charge. And it's common when there's a criminal case and a related civil case that the criminal case goes first. That's kind of normal. In part because a lot of stuff can come out in a civil case that wouldn't normally be admissible in a criminal case. And if you let the civil case go forth first, it can raise complications for the criminal case. Also, criminally, defendants have a right to a speedy trial in the criminal context. It's not true in the civil context. So the courts just normally tend to prioritize criminal matters over civil matters. Now, these were two different courts, two different jurisdictions. The criminal case was in Louisiana state court, and the civil suit was in federal court. But nevertheless, that's the normal sequence: would be do the criminal stuff first, and then come back to us with the civil. So she goes to criminal trial, and she's tried in front of a jury, and she's found guilty by the jury, guilty of murdering her husband. I covered this a couple of weeks ago when that verdict came down. And now with that guilty verdict in criminal court in hand, the civil defendants here, USCCA and those other corporate entities, went back to the federal court and said, hey, criminal court found her guilty. If she was guilty of murdering her husband, we don't have any obligation to pay her money for murdering her husband. And the federal court agreed and dismissed the case against them. Now, when you have a criminal case and a civil case, essentially involving the same factual determination to be made, say you have a murder trial in criminal court and you have a wrongful death suit in civil court, both involving the killing of another human being by the defendant. The murder trial is the state going after the defendant criminally for the crime of murder. The wrongful death suit is the survivors of the dead person going after the defendant civilly for monetary damages. Now, the thresholds for proof of liability, criminal liability or civil liability, are different in criminal and civil court. In criminal court, you have to prove guilt beyond a reasonable doubt. Let's pretend that's 95%. I'll just make up that number. It's a very high threshold. In civil court, you only have to prove it by a preponderance of the evidence. So 50% and a hair is enough in civil court. Well, the way the legal system looks at this dynamic is if you're found guilty at criminal court by 95%, well, that's way more than 50% needed for civil court, civil liability. So if you're found guilty criminally, it's essentially a done deal civilly. You're also found liable civilly. So that's a normal pattern. And that kind of looks like what happened here. She was found guilty of murder in criminal court. So why shouldn't she lose her case in civil court, trying to get money for her legal defense out of USCCA and those other corporate entities? And by the way, folks, she was theoretically entitled to $150,000 from USCCA. They only paid $50,000. After that, they denied every other penny requested. By the time her lawyer sued USCCA in federal court over this money, this was long before the criminal trial took place, much less a verdict was arrived at. By the time he sued USCCA, he'd already burned through $150,000 before getting to trial. And that's very common in murder cases, folks. It's easy when you're charged with murder or charged with manslaughter, charged with the killing offense, to burn through $150,000, $200,000, $250,000 pre-trial expense before you ever get to trial. That's how expensive these things get, which is why, it may be prudent for many people to consider something like a quote unquote self-defense insurance. As you know, in fact, I may as well mention the sponsor of today's content right now, because let me see if I can pull this up quickly. As always, unfortunately, I'm sometimes not quite as prepared as I ought to be. Let's see. Whoops. See if I can share this with all of you. The sponsor of today's content is one of the companies, is a competitor to USCCA out there in the marketplace. And they, here we go, are CCW Safe. Now, CCW Safe is a provider of legal service memberships. We generally use the phrase self-defense insurance to talk about this stuff. Usually that's technically wrong. None of these companies are really offering insurance per se. But CCW Safe is a provider of legal service memberships. And essentially what they do is, like USCCA purported to do, is promise to pay their members legal expenses if the member is involved in a use of force event. And as I just said, those expenses can get big really, really, really fast. So if you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depends on it. Because the truth is, well, it does. Whether or not you'll be free or whether or not you'll spend the rest of your life in a cage. So I've looked at all the companies that offer these kinds of services, as you might imagine, and I found CCW Safe is by far the best fit for me. I'm a member of CCW Safe. My wife, Emily, is a member of CCW Safe. Whether they're the best fit for you is something only you can decide. And no one of these programs, not even CCW Safe, is the perfect fit for everybody. But I think enough of CCW Safe that I do urge you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member there, you can get 10% off the first year of your membership with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. So of the companies that offer these kind of services, CCW Safe is my personal go-to. I encourage you to take a look, decide for yourself whether or not they're a good fit for you. Okay, so CCW Safe had denied this money for her. Now she's found guilty of criminal trial, and USCCA had denied Kayla Giles this money. Now she's found guilty of criminal trial, and essentially USCCA goes to civil court and says, hey, the criminal jury found her guilty. Obviously, then she's guilty. She shouldn't be entitled to this money anyway. She's a murderess. Therefore, you should dismiss this civil suit against us seeking the money from us for her legal expenses. And the federal court agrees. Here's the thing, folks. This is akin to you being diagnosed with cancer. And your doctor says, listen, cancer is never good. But the good news is we have a treatment, a proven treatment that can cure this cancer. Very, very, never 0% risk. But we have a solid chance of curing you of this cancer with this treatment. But it costs a lot of money. It costs maybe several $100,000. And you say, you know what? No problem. I have signed up previously for a health insurance program that promises to cover my medical costs, including for things like cancer. So thankfully, they're standing behind me. They have my back to cover the cost of this cancer treatment. So you call up, or your doctor calls up this health insurance company, and the health insurance company goes, no, we don't think this cancer can be cured. We don't think we think it's just mortal, fatal cancer. She's done. That patient is done. That's it. And the doctor says, well, I disagree. I'm her doctor, and I'm prepared to treat her with this therapy for cancer. The hospital, at which the therapy would be provided, they agree that this is the proper path, that she's entitled to be treated with this medication, that it's appropriate. The company that provides the therapy agrees that this is the kind of patient for which that therapy is most appropriate. We all agree that she needs to get this therapy, and you promise to pay for the therapy. And the insurance company says, no, we're just not going to pay. And if you don't like it, sue us. So you do. You sue them. But of course, lawsuits, civil suits take forever. And in the meantime, you have the cancer. And you don't have the therapy. More specifically, you don't have the money to pay for the therapy. So you don't get the therapy. And then when you don't get the therapy, the cancer kills you. And when the cancer kills you, then the insurance company says, see, that patient was just going to die anyway. Giving them the money for the therapy would have been pointless. Well, that's what USCCA is effectively arguing here. They're arguing, well, she lost a criminal trial, so that just means she's a murderess. We shouldn't be obligated to pay for someone to murder their husband, should we? Well, here's the thing, folks. Would she have been convicted if she'd had the money to mount the legal defense that might have been necessary? I can tell you from my personal and professional experience, there is a world of difference between a $50,000 legal defense and a $250,000 legal defense. Did she get convicted because they couldn't afford the expert witnesses? They couldn't afford the depositions? They couldn't afford their own forensics experts to examine the evidence? They couldn't afford their own detectives? They couldn't afford to do what was needed to effectively impeach the state's witnesses? Is that why she got convicted? Because she didn't have the resources she needed to have a fair fight at trial? Now, I don't know if that's the case. None of us can know, right? Just like we don't know if that hypothetical patient would have gotten the cancer therapy and died anyway. We don't know. But the reason you sign up for one of these programs is so you'll have a decent shot. So you'll have the resources to make the argument. Maybe you make the argument and you lose anyway. Maybe you make the argument and your self-defense insurance company pays for your legal expenses and you get convicted anyway. Sure, that can happen. But they did what they told you they were going to do. If you're allowed to argue self-defense in court, they had your back. They provided the resources your attorney believed he needed to wage the legal battle that you deserved, to have a reasonable shot and an acquittal. So I know there'll be people out there, probably USCCA among them, saying, we told you so. We told you so. We told you the civil suit would go away because she was going to get convicted of criminal trial. But was that a self-fulfilling prophecy? Because by denying her the resources, did you condemn her to a conviction that might not have happened if you'd kept your side of the bargain? And there was nothing, because I've read it, the USCCA agreement that was in place, the terms and conditions that were in place at the time that Kayla Giles was applying for her benefits from USCCA, there was nothing in that agreement that said, hey, if it doesn't feel like self-defense to us, we reserve the right to not pay. That wasn't in there. Now, there are some of these companies out there, competitors to USCCA, that do have that kind of condition in their program. And I have nothing against such a condition. Armed Citizen Legal Defense Network. I think they're a fantastic organization. Marty Hayes runs that organization. He does a fantastic job. Their board of directors is unbelievable. It's Tom Givens, it's Mas Ayub, it's Dennis Tuller, it's John Farnham. I mean, these are giants in the self-defense and self-defense law community. It's a fantastic organization. But when you sign up, they tell you, hey, if you're a member and you're involved in a use of force event, our board is going to look at that event. And if it doesn't look like self-defense to us, we're not going to cover you. And you know that going in because they tell you that going in. USCCA didn't do that. They didn't tell people that's a condition of being covered, that we get to decide after the fact whether or not it looks like self-defense to us. I wouldn't have a problem if they had done that. Then, well, you take your chances. Then it's we'll cover you if we feel like it program. But that's not how they sell it. In their marketing materials, at least the ones that were in place leading up to Kayla Giles' case, in their marketing materials, they have the president of the company, the founder of the company, in their marketing materials saying, hey, we've got your back. It doesn't say we've got your back asterisk unless we, non-legal professionals, non-experts in use of force law, non-criminal defense attorneys, unless we think it doesn't look like self-defense to us, and then you're screwed. Is that the kind of program you want to sign up for? Obviously, I'm not telling you not to sign up with USCCA. They have other features. They have training. They have a very nice magazine. They're on a personal level, they're very nice people. I've met many of them, many of their senior management. I used to be on their legal advisory board. On an individual level, they're very nice people. But you don't sign up to be a USCCA member because they're nice people. You sign up in case somebody attacks you or your family with a machete and you defend you and your family and then find yourself criminally charged by some rogue prosecutor who wants to put you in prison for the rest of your life, then you'll have the resources you need to fight that prosecutor. That's why you sign up. But that's not what Kayla Giles got. And again, we'll never know what the legal outcome might have been in her criminal case had she had the resources that USCCA purported to promise her if she was involved in a use of force event and a court allowed her to argue self-defense. So that is, I guess, all I have to say about that. So much. Hopefully, I'll never have to touch base on this particular topic again, as it's become, if it's not tiresome to you, it sure is tiresome to me. All right. So I have another topic here. I'm going to save that one to the end because that's a happy note, and I'd like to end the show on a happy note. Here's another case I'd like to share with all of you. For some of these folks, I'm going to share the news story. I'm not so I feel obliged to say this. I see someone commenting that they're members of the Law Shield program. I've talked with the guys at Law Shield, the senior people, the management there. They're very nice guys. Very nice guys. But Law Shield is not a program I can recommend. The way Law Shield works, and please feel free to call them directly and talk to them. I don't pretend to be an expert on every nuance of each one of these programs that are out there. So I'm speaking generally. The way Law Shield works is they essentially contract with attorneys where they say, all right, we'll pay you a monthly fee to be available to defend one of our members should that member be available, be involved in a use of force event. And the theory is that the many months in which those lawyers don't get a call, they're accumulating those monthly payments. And then when they get a client come in the door through Law Shield, they cover that client for free. So they don't charge that client. They don't charge Law Shield. That lawyer's compensation is whatever the accumulated monthly fees they were paid as being an associated lawyer with Law Shield. So they may, I guess in theory, they may never get a call from Law Shield to cover any client, any member of Law Shield, in which case they've just made that money every month. But here's the problem. If they do get a call, the prospect that the money they're getting paid month to month is within 1% of what it would cost to actually wage a legal battle in defense of that client, it's not even close, folks. Maybe if it's a simple assault or battery case, we're talking 20, 25 grand, 15 grand, something like that, maybe a little less. Okay, maybe that works out. But for the amount that U.S. Law Shield pays these attorneys on a monthly basis, if you're charged with murder, which could easily run into hundreds of thousands of dollars of legal expenses a year or more of a lawyer's time, there's no way that relative pittance that Law Shield is paying those lawyers is covering that legal defense, which means either the lawyer, if he's ethical, simply won't take the case, in which case, what was the point of being a member of Law Shield in the first place if their lawyers are not going to take your case? Or they'll take the case, and then their entire financial incentive is just to get it over with quick, which means do a plea. Get you to take a plea. And, sometimes taking a plea is the right call. But in this case, it's like the only call, because no attorney is going to spend a year of his time and several $100,000 of billable hours to work for free, or the next closest thing to work for that small amount of money Law Shield was paying them every month. That's not happening, folks. So again, I've looked at all these programs. The one I found that is the best fit for me, that I have the greatest confidence in, is CCW Safe. And it's not just because they cover their members without monetary limit, by the way, and they'll cover an appeal, they'll cover a retrial, all without a cap. But they have other facets as well. They have attorney Don West is their national trial counsel. Don West was one of George Zimmerman's attorneys. Don is a world-class criminal defense attorney. And in full disclosure, I didn't know Don at the time of the Zimmerman trial, but we've become good friends since then. He's a great attorney and a great guy. And any defense with Don on their legal team is head and shoulders above not having him. So there's other kind of intangible assets that CCW Safe brings to the table as well. But Law Shield, I'm sorry, I like them. I like them as people. They're nice people. They're good people. I believe they're well-intentioned people. But the program itself, if I were advising my own children what to get, my adult children, I couldn't recommend Law Shield. Sorry. Or any of the Shield programs. I know that there's some of them are specific for states, but if it has Shield in it, it's the same structure. All right, so the next story I wanted to share. Enough on the self-defense insurance stuff, but I did want to touch upon that quickly. So the next story I wanted to involve was a police shooting here. Let me make this a little bigger. Okay, come on, Andrew. You can do better than this. There we go. So this was an officer-involved shooting. It says at a Sportsman's Warehouse. The only reason Sportsman's Warehouse has anything to do with this is that the bad guy fled to the parking lot and got shot by the police in the parking lot. It doesn't really have anything to do with Sportsman's Warehouse. It's not like it happened in the store or anything. The initial confrontation between the bad guy and the police happened elsewhere. He fled in his vehicle. Two injuring officers in the course of the flight, by the way, to this parking lot that happened to be a Sportsman's Warehouse. And when he was approached by officers in a special unit, it had an odd name, Special Investigations Unit. And this happened in my home state of Colorado. So this was Grand Junction, Colorado. If you've never been to Grand Junction, well, don't bother. There's not much there. But this happened in Grand Junction. This guy was, let's see, I'll step through the story here. See if I can make this font a little bit bigger so it's easier to see. So, Mark Madison was the suspect. He survived the shooting, by the way. So he's also facing criminal charges for his conduct in the course of the shooting. Prior to this interaction with police, he had an outstanding arrest warrant for domestic violence. The cops saw him driving around, a couple of uniformed cops. So they made contact, advised him of the warrant, said he was being taken into custody, and he refused. One of the officers tased him. One of the uniforms tased him twice, and it didn't work. Folks, the tasers, when they work, are amazing. They're like miracle devices. The percentage of time they do not work is unbelievably high. So it's good that officers carry them. It gives them another option, another tool on the tool belt, literally. But they very, very often don't work. And nobody knows this better than the cops that deploy them. So they tased the suspect Madison twice, unsuccessful. The suspect flees on foot. The two uniforms follow. And we'll see later that there are some now Soros-sponsored prosecutors who are arguing with a straight face that police should not even be permitted to engage in foot pursuits of criminal suspects, because that's over the top, apparently, for law enforcement. You're just supposed to let the bad guy walk away. You're not even allowed to pursue on foot, according to some prosecutors. But these two, that's not the standard in Grand Junction. So these two uniforms follow the suspect, Madison. He turns back to them and he initiates a fight with the officers. He attacks one of the uniforms, leaves him disoriented, suffering a leg injury, so he can't support his own weight. So he's out of the fight. And then he jumps into his car, a black Mazda hatchback, and races away. But the other uniform was able to get the plate number, description of the car, and the direction of travel, and radioed that out so that a couple of guys from the Grand Junction Special Investigations Unit in unmarked cars, two guys in separate cars from the Special Investigations Unit, engage in now vehicle pursuit. Although I don't believe the suspect knew he was being pursued because of the nature of the unmarked cars. So it wasn't like a high-speed pursuit. They're just following him. He's just trying to drive away someplace, and he pulls into the Sportsman's Warehouse parking lot, backs into a spot between two other vehicles. I mean, he's hiding, right? Hoping things will calm down enough for him to get away. The Special Investigations Unit guys, the plainclothes guys in the plainclothes car, park their vehicles in such a way as to block him in. They draw their guns. They take him at gunpoint while Madison is sitting in his car, and they order him to give himself up. Instead, what he does is the suspect produces a gun of his own, holds it up, and the officers open fire. Now, it would later be determined this gun the suspect had was actually a BB gun, not a real gun. But it looked all the world like a real handgun, and the officers responded appropriately. They shot him, grievously wounded him, but they got him. They provided care. They got him to a hospital. He survived, and he's facing now a number of criminal charges, including 3 counts of assault on a peace officer, 4 counts of felony menacing, resisting arrest, obstructing a peace officer, violation of bail bond conditions. So this all happened last year in June. And this is one of the real take-home messages why I'm sharing this with you. This all happened last June. And it was only this past week, see if I have a date here, yesterday, March 22nd, that the district attorney in that jurisdiction announced that those officers who fired those shots, and by the way, they fired 28 shots, would not be charged for having shot this suspect who created a reasonable perception that he was imminently about to use deadly force in the form of a pistol against those officers. There's a picture of the gun, the suspect's gun, folks. I mean, sure, on close examination, if you were holding it in your hands, it might be pretty obvious it's a BB gun, but not when someone's waving it at you, for sure. And here's an update. That suspect has been convicted of those criminal charges I just listed for you, so he's been sentenced to 14 years plus parole. But the district attorney now says the officers responded lawfully and appropriately. 28 shots is a lot of appropriateness, folks, in defense of themselves and others. Accordingly, it's not appropriate to file charges against the 3 officers. So it was the 2 plainclothes and I guess a uniform caught up, and he also fired some of those shots at the suspect. The reason I want to bring this up is these are cops who were engaged in a use of deadly defensive force in pretty clear-cut circumstances. The suspect was waving what to all the world appeared like a gun in his hands. And about as clean a police use of deadly defensive force as one could imagine, given these circumstances. And yet it took from June to March for the prosecutor to decide he was not going to bring charges against those officers. So what, June, July, August, September, October, November, December, January, February, March. That's 9 months, folks. Took 9 months before these officers could be confident they were not going to be charged for their firing of shots at this apparently armed and violent suspect. 9 months. That's 9 months their life is on hold, really, right? Because if you're going to be charged, it's almost certainly going to be a murder or manslaughter charge. The guy survived, so it wouldn't have been murder or manslaughter. It would have been aggravated battery, for example. Maybe some added reckless endangerment charge for the volume of shots that were fired. But you're looking at the end of your life as you know it. So if you could find yourself tried for aggravated battery with a firearm, which in most jurisdictions is good for at least 10 years, with the gun enhancement, maybe 20 years. So you could be looking at 20 years in prison. And for 9 months, you don't know whether or not that's your fate. Do you get married? Do you have kids? I mean, your life is on hold, right? You're not going to birth a child and then learn you're going to spend the next 20 years in prison. And I mention this because, folks, it's one of the consequences you need to keep in mind when you're thinking about, should I go to my gun? Now, I'll always say the top priority always has to be to win the physical fight. If you don't win the physical fight, everything else becomes less pressing. But you need to think long and hard and before the moment of crisis about what circumstances in your mind to you. I'm not telling you where that red line should be drawn. I'm just telling you to draw that red line ahead of time in an informed way so you understand the risks that you're taking. And this is the least of them. I mean, these cops ultimately were not charged. But for 9 months, their life was on hold. Is it going to be a shorter period of time for you? And of course, there's always the risk that you will be charged and you will be tried and you will be convicted. Just another one of those, even if the facts of the case are about as clear-cut a case of lawful use of defensive force as you can imagine, as I would suggest these facts were. So something to think about. All right, let me scroll. Let me see if I can do a reasonable job of opening this up. See if there's any super chat questions I need to answer now before I move on to the next story I wanted to share with all of you. Let's see. Well, William White, thank you very much for your super chat contribution. You didn't ask a question, but I really appreciate the contribution. William Andrews, excuse me. William Andrews says, if you were invited on Timcast in the future, would you consider setting up a member meeting in the Maryland area? I probably wouldn't, William. Not because I don't think the members of the law self-defense community who are in Maryland are unworthy of a member meetup. I would love to do a member meetup on those grounds. But when I announce these member meetups, I don't know who's going to show up. I mean, no offense, but it's the internet. And there's always a risk that, I've gotten my share, more than my share, of death threats over the years based on trials I've covered and worked on. So I carry a gun for a reason. I carry a gun because there's crazy people out there. And unfortunately, Maryland is a state I can't carry a gun in lawfully. So, which means I won't carry a gun there at all, of course. I'm law abiding. So if I had a member meeting in Maryland, I'd be effectively unarmed and not knowing if some crazy person was going to show up to a member meetup. So probably off the table as a member. Just talking to Tim's people this past week, I think the chances are unlikely I'll be on again soon, but there's a possibility. There's a little hook of interest there. It's I'm not sure it's enough to warrant me flying out to Maryland to be on the show, but I'm a huge Tim Fool fan, and as far as I can tell, he and his team are fans of mine. So I'm sure I'll be on there again sometime in the future. But thank you for asking. Let's see. Anything else? That's it for the moment. All right, let me proceed on then to the next story I wanted to cover. Oh, by the way, I was very pleased to hear there's yet another constitutional carry state. I forget now which one it was. I think, was it in Indiana? Someone can correct me in the comments if that's mistaken. I believe that's number 24. As most of you know, I personally and professionally believe that every single gun control law that's preemptively applied to law-abiding, mentally sound American citizens, and we're all presumed to be law-abiding and mentally sound, is facially unconstitutional. Every single one of them. So I'm all in favor, as you might imagine, in constitutional carry. I would urge you to consider getting a permit anyway, because that permit can be handy for a variety of purposes. I can tell you, I've been in interactions out of state where I've had to explain to an officer that I had a gun on my person. And it was very helpful to have a non-resident permit on my person for that state that I could show that officer. I have to say, he'd never seen one before. He'd never seen a non-resident concealed carry permit from his own state before. But at least I had something issued by his state, and it kind of gives you it separates you from the guy who just may be carrying a gun in his pocket with nothing. Doesn't mean you have to have it. But I believe in that experience I had, that it lended a certain degree of credibility to me that I might not have had if my only fallback were, hey, it's constitutional carry. So, but the more constitutional carry, the better. The fewer gun laws, the better. We're all, for all us law-abiding, mentally sound American citizens, it ought to be our call and nobody else's whether or not we're carrying a gun for personal protection. All right. Next story. Okay, that was Grand Junction. Let me now go to this story out of Wisconsin. It's only vaguely a use of force story. Force was used, and now accusations are being thrown around. But I will. I want to touch on it because it has implications for societal safety generally, especially for our children, but also generally. And And that has implications for whether or not it's more or less likely for that we would find ourselves in circumstances where we might be compelled to use force. So here we have a story out of Wisconsin. The headline is, let's see if I can make this a little bigger too. Wisconsin, all these ads. Unfortunately, folks, some of these news websites, they won't let me view the article or share the article like this unless I turn off the ad blocker. And this is one of those. But this is a story out of Wisconsin. Wisconsin dad wants cop charged for restraint of daughter. So this is the daughter was in high school. You see her there. I believe that must be the cop there. The daughter's in high school. She gets into a confrontation with some other student, a physical confrontation. By the way, that physical confrontation was sufficiently severe that she herself is facing criminal charges for her use of force on the other student. The officer in the school, he was off duty, but in the school. So not a school resource officer, I guess, but maybe, I don't know why he was there. They don't tell us. Perhaps he was a visiting parent of his own student in the school. In any case, he's an off-duty police officer, sworn officer, sees this fight happen, and he feels confident that this girl is sufficiently at fault that he places her under arrest, and she's resisting arrest violently. So he gets her on the ground, and he puts his knee on her back or neck. That's the point of dispute. He puts his knee on her to keep her restrained while he cuffs her up. Now her father is, of course, wants to sue the department, maybe sue the school. I don't know. Sue everybody is normally how it's done. Because this officer, he says, had George Floyded his daughter. That officer's knee, and of course the father claims the knee was on his daughter's neck, came within inches of killing his daughter. Of course, I expect if we asked the daughter, he'd say, if we asked the officer, he'd say, no, my knee was nowhere near her neck. It was between her shoulder blades because she was violently resisting lawful arrest, and I'm privileged to use force to compel compliance. But in any case, the father now claims he has still photos from the surveillance cameras inside the cafeteria, presumably the same cameras that caught this frame, and he's alleging, what's he alleging? There's a little quote from him here. I'll find it and highlight it. Whoops. It's let's see. Oh, here it is. The father posted this fuzzy image in which he claims the officer had his knee on his daughter's neck and says, and he posts it next to a picture of Derek Chauvin having his knee on George Floyd's neck. And he writes with those comparison photos, tell me what's the difference. Luckily, he ain't kill my baby, says the girl's father. Now, the local prosecutor and the police have investigated this, and they say, nope, there's nothing here close to George Floyd. There's nothing like this. But of course, if you reach out to the civil rights community, they have a very different view. They largely don't really care what the facts are. Of course, they're pushing a narrative, not facts. Here's one, Daniel Adams, a former Milwaukee County assistant prosecutor who now works as a defense attorney. This is what the prosecutor's office looks like. People like Daniel Adams. He felt differently than the actual DA did. He called the video shocking and the officer's use of force intolerable. A law enforcement officer may only use the level of physical force necessary to carry out their job, he wrote in an email to the Associated Press. So you think he's trying to get media coverage for himself and is willing to burn a cop at the stake in order to get that Associated Press coverage? He continues, does Attorney Adams, here there was no necessity in using that level of force. In my view, the Kenosha District Attorney has probable cause to charge the officer with strangulation, suffocation. These are effectively attempted killing crimes, and battery under Wisconsin's criminal code. Now, this officer is not going to get charged with strangulation or suffocation or battery. The local prosecutor has said as much, but he could have been. This Daniel Adams worked in the prosecutor's office previously. He could have made the call to prosecute this office if he was still in that prosecutor's office. So it's not up to the officer whether he gets charged. It's up to these prosecutors. And this officer did this because he saw a sufficiently violent attack by one student on another that the student who was arrested is herself facing criminal charges. See if they're listed here. I know I saw them when I first, they just, the way they drop in these ads is terrible. Well, I believe I saw criminal charges were being levied against the student who was arrested. So this was not like two kids shoving each other. This was a bad enough arrest, use of force by the student that she was subject to arrest facing criminal charges. If this officer were charged, or even just people arguing he should be criminally charged for protecting one student from another student's attack that was sufficiently violent to warrant criminal charges, do we really want to chill our sworn police officers from defending students and arresting aggressors in these circumstances? And if police officers, and imagine your child was the victim of that attack, an attack on your child sufficiently severe that it warrants criminal charges. Would you want that off-duty officer to come to the defense of your student being subject to that attack? And if we tell the officers they can't do that, who do you think is going to step up and do it? If a sworn officer can't do that without facing a real risk of criminal prosecution, you think a teacher is going to step up? You think a hall monitor is going to step up? You think a guidance counselor is going to step up? Or are they just going to stand back, watch your child get beaten, and then afterwards everyone else will say, oh my gosh, I can't believe no one stepped in to help that poor child. I can't believe they all just stood there and watched. You know why they stand there and watch, folks? Because of this. Because of people like this former district attorney, assistant district attorney, I presume, arguing that this officer should have been charged with strangulation for his conduct in securing the safety of that other student and affecting the arrest of the aggressor in this case. That's why people don't step up. Because if they step up and some rogue prosecutor decides they don't like them, they don't like the way they look, or they don't like the way they conduct themselves, or they see an opportunity to aggrandize themselves in the media, that prosecutor can destroy that person's life. That's why people don't step up. And if we want a world in which people are willing to step up and do the right thing, we need to create a world in which that person has a reasonable expectation their life will not be destroyed for having stepped up. So there's an unstated consequence to all these hyper-aggressive prosecutions of people who are using force in apparent reasonable defense of themselves or others. And the unstated consequence is that the bad guys get to act with utter freedom and without constraint and without any reasonable prospect of being constrained or punished from their use of violent, aggressive force against innocent people. I've always said, the respected self-defense community has always said, you are your own first responder. No one is coming to help you. No one is coming to help you in time. What's the cliche? When seconds count, the police are only minutes away. Well, increasingly, the police may be scores of minutes away, hours away, an infinite amount of time away, because they've been completely disincentivized from using force against criminal aggressors. I don't think that's a world we're going to enjoy very much, folks. Oh, I guess I had a full-time commercial running there on the side. Sorry about that, folks. All right. Next story I wanted to share with all of you. This was, maybe this one's a little too gruesome. Okay. Here we go. So there's another case involving not just speculatively Soros-funded prosecutors, but actual Soros-funded prosecutors. And in fact, before I jump into that, let me check the super chats again, just to make sure I'm keeping on top of things, and it looks like I am. Let me take a look at the, where is the, okay, the Law of Self-Defense members. David, thanks. Good to see you. David's often in these chats. Mike, also often there. Ryan, nice to hear from you, Ryan. Let's see. Yeah, David writes, this is why, going back to the USCCA story I covered, this is why I have CCW Safe and a platinum membership with you. Of course, we have our own platinum level membership option. The only people who receive our, meaning our Law of Self-Defense, my legal consult on their self-defense cases, are people who are members of the Platinum Protection Program. These letters I get, emails I get from people who have used force and finding themselves criminally charged or needing to appeal a conviction on a use of force charge, who are not Platinum Protection Program members. I can't help them, folks. I guess more accurately, I should say, I won't help them. I'm not going to divert my time away from the people who have chosen to participate in the law of self-defense community, take time away from them to give to people who haven't made that commitment. So the only people to whom I provide legal consults are people who are members of our Platinum Protection Program membership. You can learn more about that at lawofselfdefense.com/platinum. And that's what David is a part of here. So he's a member of CCW Safe, which is his own organization, of course, and the Law of Self-Defense Platinum Protection Program. And thank you for that. It's much appreciated, David. Thank you, Mike, for the kind words on the beard. David asks, Andrew, have you been following the Supreme Court nomination? I've been listening to it with Uncivil Law. I think this nominee is nothing but a train wreck. She's not really a lawyer. I don't care what her credentials are. She's an ideologue wearing the cloak, a rubber mask of a lawyer. The questions she's being asked that she's unable to answer, like what qualifies as a woman. She's a woman, by the way. She was nominated for this Supreme Court vacancy in large part because she is a woman, also because she's of color. Joe Biden himself has said that. So she's been nominated in large part because she's a woman and she can't define woman. Her answer is that, well, I'm not a biologist. So apparently she can't identify herself as a woman because she herself is also not a biologist. Is that someone being honest, sincere in a Supreme Court nomination hearing? Or is that someone who's just wants to hide their ideology long enough to bring critical race theory to the Supreme Court? Guilt by class group, by race group, by gender group, not individual guilt, not judged as an individual American citizen on the law and the facts, but guilty because you're the wrong skin color, or you're the wrong gender, or you have the wrong political opinions. Even if you don't, your group does. That's why you're guilty. You want that as a Supreme Court justice? Because that's what we get. She's confirmed by the U.S. Senate. That's my opinion on nominee Jackson. But I can't say I've been following it closely. I'm just seeing the news snippets. I'm sorry. It's not a use of force event, and I focus my work time on use of force stuff. Let's see. Mike asks, would you consider doing a video with CCW Safe to discuss the Giles versus USCCA case? I don't think so. I mean, it's not that I would mind. One, I'm not sure they'd be interested. You know, I mean, most organizations, if they're conducting themselves professionally, they don't go directly for the throat of their competition. They just perform a good job, do a good job for themselves and their customers, and they hope that's, you know, carries them through the market. And that's CCW Safe is a very professional organization, so I would not expect them to be interested in going at the throat of USCCA in that way. Also, I mean, I don't work for CCW Safe. I'm free to say anything I want about USCCA, and I do. And I've given my opinion at length in many blog posts, many videos, many podcasts. So I wouldn't really have anything to add on top of what I've already said. So I would not expect it to happen. It's not because I do videos with CCW Safe all the time, but I wouldn't expect them to be interested, and I wouldn't be inclined to do a video targeting USCCA specifically. All right. So those were all the Law of Self-Defense member questions. It looks like another super chat may have come in on YouTube. Let me take a look at that real quick. Come on, YouTube. Are you working? Working hard or hardly working? Okay, William Andrews, another super chat. Thank you again, Williams. All good. He was going to joke that I would be arrested on arrival. So William had asked if I would do a member meetup at in Maryland. I explained why I wouldn't, because I'm not legally privileged to carry a firearm in Maryland. And he says, yes, I was going to joke that you would be arrested on arrival. Yeah, I assume, well, I have to presume that if I showed up in Maryland with a gun, I would be subject to arrest upon arrival, which is why I don't do that. He also adds another super chat. Thank you, William. You bought me lunch today. Thank you very much. It's much appreciated. He writes, Ian Runkle covered shooting of Roger Katenko, a Canadian gunsmith shot by police carrying out a warrant. Interesting hypothetical, could happen here. Anytime police are responding to a shots fired or a gun on scene call, they're going to be on edge, and they care about their lives and they don't want to get shot and killed. And so their propensity to use deadly defensive force will be at a heightened state from the very beginning. I can only imagine that's even to a greater degree true in a place like Canada, where there's far more restrictions on gun ownership than we find in America. I don't know. I'm just speculating on that point. But sure, anytime guns are involved. And by the way, this applies in all those, those very sad and dangerous swatting type episodes. Several, prominent people in, certainly my social network on the internet, prominent YouTubers and bloggers have found themselves swatted in recent weeks and months. And these are life-threatening events, folks. These are like running up and pointing a real-looking fake gun at a cop's face. I mean, what do you think is going to happen? So anytime the police respond to these swatting calls, especially when they're being made against people, and they usually are, against people who are law-abiding American citizens who have their own guns, things can turn deadly very, very quickly, even though all the parties involved are acting innocently and with the best of intentions. The swatter made that happen. I look forward to these swatters being prosecuted for attempted murder, because certainly if I were a prosecutor, that's how I would treat a swatting call claiming to involve deadly force events, or events that would privilege police to use deadly force. That's how I would treat that. As far as I'm concerned, that's an attempted murder. And the punishment for attempted murder is the same as the punishment for murder. Just because you failed doesn't mean you get a lesser punishment. So thank you for that, William. Okay, next story I wanted to cover, that was Wisconsin. This is Chicago. This is State's Attorney Kim Foxx in Chicago. She's a Soros paid for prosecutor. He bought that seat for her. And of course, anytime that happens, the city has devolved, an already violent city has devolved unbelievably into higher levels of violence. And of course, that's because that's what they want. They foster unbelievably increasing levels of violence. This involves two separate shootings that occurred of suspects by police in the Chicago area. One of these involved a 13-year-old. I believe both the suspects were young black men. They were shot and killed by police. And the Kim Foxx has just announced she's not going to charge those police officers. Well, there's good reason why they shouldn't be charged. Neither of those officers, none of the officers involved in either incident should be charged, because in both cases, the suspects were visibly armed with guns and non-compliant with lawful arrest, and bringing those guns to bear, or apparently bringing them to bear. One of them threw the gun away an instant before the police fired. So the police still had reason to believe he had a gun in his hand. It was less than a second, a fraction of a second, between divesting himself of the gun and getting shot. The police officer's mind in such a circumstance, it's already sent the signal to shoot. So it's over. The officer, what counts is not the moment the officer's bullet leaves the muzzle. What counts is the circumstances as they existed at the moment the officer made the irrevocable decision to fire the shot. And at that moment, the suspect still had his gun in hand, turning to face the police officer after a foot pursuit. of this armed suspect. Apparently, well, I should say, if you didn't know, it's common for adult gang members in the Chicago area to keep underage minor children with them, beside them, in possession of guns. So the child holds the gun for the adult. That way, if the police grab them, the adult is not in possession of the gun. The child is, and of course, the punishment for the child being in possession of the gun is much less than that for the adult. Plus, I mean, the adult doesn't care. The adult wouldn't care if it was life for the child. It's just the adult's not getting charged. At the same time, the adult has a gun about as close as if the gun were in a glove box, right? So the gun is readily accessible. Frankly, in a just world, every single one of those adult gang members doing this would be charged with constructive possession of a gun. If a gun is found under the passenger seat of your car and you're not allowed to have guns, the prosecution will argue that you had constructive possession of that gun. Sure, it wasn't tucked in your waistband, but it was effectively under your control. The same should be done in these cases. But of course, these supposedly anti-gun prosecutors, they're not really against guns per se. They're not against bad guys having guns in particular, because most of the bad guys fall within their constituency. They don't want to put their own constituents in prison. They're against law-abiding people having guns. So they use guns as an avatar of evil to paint as monsters law-abiding people have guns, but they don't do anything to bad people who actually have guns. Those charges are never brought or dismissed. If they wanted to aggressively pursue gun charges against criminals who are prohibited from possessing guns, they could do that. And then you get what happens to the prosecutors and the other politicians in that jurisdiction, what happened during in New York City when they had stop and frisk. Yes, civil rights protests against stop and frisk, which was a very effective mechanism for keeping guns off the persons of criminals in that jurisdiction. But all these prosecutors, they know if they wanted to reduce crime, they have the means readily at their disposal. They don't want to reduce crime. That's not their goal. So here we have these two officers, or at least two events, shooting events. And Kim Foxx has decided she's not going to charge these officers. There'd be nothing to do here. It would be pure theater. These were as clean police use of force cases, fatal use of force cases, as could be imagined. All the officers involved here were facing criminal suspects who'd fled on foot, then turned and apparently pointed guns at them, and actually had possession of real guns. So what does Kim Foxx have to complain about? She can't just say, no, we're not going to charge these officers because they don't deserve to be charged. No, she's arguing, well, I'm not going to charge these officers, but they still suck. How do they suck? Well, they didn't have to engage in a foot pursuit. The foot pursuit is what made this all happen. See if I can find some quotes. Kim Foxx says, let's see, where's her killer quote? Foxx said her office considered first-degree murder charges against one of these officers, but said she believed there wasn't evidence to support those charges, citing state law that allows officers to use force if they reasonably believe they are in danger at the time of the shooting. Oh, how about that? You don't just have to let the suspect shoot you. You're allowed to use deadly force if you reasonably believe that that's armed suspect with a gun in hand who's resisting lawful arrest presents a danger of death or serious bodily injury. However, Foxx said she can't leave it at that. She has to say, however, the officers themselves created the conditions which the use of deadly force became necessary. Did they really? What did they do? They engaged in foot pursuit of armed suspects, non-compliant with lawful arrest. Is that creating the conditions in which the use of deadly force was necessary? I mean, we could just fire the entire police department. We could have no police, and then no police officer would ever use force against a suspect. Then they definitely could not create the circumstances in which deadly force was used because they wouldn't exist. That would be the only way in which they could never create the circumstances in which deadly force was used. She goes on, Foxx was critical of both officers' decision to pursue the suspects. noting that one of their partners had called out to the suspect by name. The officers were aware of the suspect's home address and could have sought to contact him there. So a suspect that's going to flee a cop, a suspect gun in hand that's going to flee a cop on the street is going to just wait for that cop to show up and comply with arrest when the cop comes to his house, his place of security, the place where he could well have many more guns stashed, where he knows the layout of the house and the escape routes in the neighborhood. That person who fled the first lawful arrest is now going to comply with a second encounter at his home. Why would anyone believe that to be the case? Kim Foxx also said it was unnecessary for the officer to stop and engage the suspect who was not committing any crimes that were readily apparent to the officers at the time. They just stop and engage people because nothing, no reason. That's what cops do. And then it turns out the person flees because they have a gun in hand. That's how that works. I don't think so, Kim Foxx. By the way, the cops were stopping this particular suspect because he'd been stopped the night before for a traffic violation and had fled that stop. So this is a pattern of flight. And why not? It works, apparently, as long as you don't actually point a gun at the cops. But apparently in Chicago, if you flee the police, they'll let you, or they're supposed to let you, according to their own prosecutor. Again, folks, if the police are told that they're not to even engage in foot pursuit of a suspect for fear that they might be compelled to use force when that suspect points a gun at them, why would they pursue anybody? They don't know ahead of time if a suspect's going to draw a gun and point it at them. And then if they use deadly force in self-defense, they're told, well, you shouldn't have engaged in a foot pursuit. You created the circumstances in which that deadly force is necessary. That's on you. It's not on the suspect. Non-compliant with arrest, fleeing from arrest, pulling a unlawful gun and pointing it at you. It's not his fault. It's your fault. It's your fault for engaging in a foot pursuit in the first place. For perfectly lawful reasons, engaging in a foot pursuit. That's on you. If that's what officers are told, why would they pursue anybody? And if they're not pursuing anybody, and criminals know they can simply walk away from any confrontation with police, any attempt by police to make their lawful arrest, why wouldn't they? And if they're not even going to be subject to arrest, they're certainly not going to be subject to charging. And if they're not subject to charging, they're certainly not going to be subject to prosecution. And if they're not subject to prosecution, they're certainly not going to be subject to conviction and imprisonment. In other words, there will literally be zero legal consequence for them breaking the law. Do you want to live in a world where there's zero legal consequence for breaking the law? Frankly, if we're not going to allow our police to engage even in foot pursuit or be held responsible for everything that follows if they do, why even have police? Why do they exist? Why are we paying them? Why not encourage the officers who want to do the job of an officer to move to a department that will pay him to do the job they want him to do? Why work in Chicago, where you might find yourself subject to prosecution for first-degree murder under State's Attorney Kim Foxx because you initiated a lawful foot pursuit of a suspect? I don't know why. I guess for the cops who are getting close to pension time, I guess they're taking the risk. But what kind of young cops do you think are getting recruited into Chicago PD? You know how many police departments nationwide have an unbelievable shortage of officers? Maybe half the staffing levels they're supposed to have. And they're invariably cities in which the local prosecutor is a Soros-funded prosecutor, and the local mayor is of a similar political temperament. And those police departments are at 50%. And you know the 50% that left those departments, folks? Here's a shocker for you. It's not the senior level echelon of that department. Those 20%, 25% of the department, they stayed. They're senior. They're close to pension. They're not on the street. Any officer with the pull has gotten off the street. They're either in the administrative part of the agency, or they're at the academy, or they're doing some other function that does not raise a risk of going hands-on with a perpetrator on the street. So all the experienced cops are the ones who leave first, the ones who might be at risk of going hands-on and then finding themselves criminally prosecuted. So all that's left is at the very bottom, the guys who've been on the force maybe a couple of years, maybe weeks or months. You know that at least 2, maybe 3 of the 4 officers involved in the George Floyd arrest were on the force for weeks. One of them, it was his first street assignment ever on the department. That's who your police force becomes to be made up of, people with zero experience in doing this job. And you think we're going to get better use of force decision making from people who've been on the job for weeks or months, maybe a couple of years, than we're going to get from people who've been doing that job for 5 or 10 or 15 years? I don't think we're going to get better decisions. So what these policies have done is not only what they've done in the immediate term, prosecute these cops, disincentivize every cop from doing the job of a cop, encouraging officers to flee the department if they're at any risk of having to go hands-on and be subject to these sorrows from the prosecutors. We've created police departments in which the actual cops on the street are effectively incompetent. No offense to them. They're brave men and women. They're doing the job as best they can, but I'm sorry, no one's super competent on their job if they've only had it for weeks or months. Not a job as highly complex as that of being a police officer in these politically charged times. So what you'll get is you'll get cops who are incompetent and or just won't do the job. And by the way, we've seen this in Minnesota, right? We had Mohammed Door. Was that his name? Door? D-O-O? Moore? I'm vague on the last name. This was I believe it was a Minneapolis police officer who responded to a call of a possible rape in an alley by a woman resident in the neighborhood. The woman resident came down to chat with the cops in the police car when it appeared they were going to drive off without having seen anything. And Mohammed Door just simply drew his gun and shot her as she approached the car, killed her. Was that an act of malice on his part? I mean, he was prosecuted and convicted of manslaughter. Or was it just that he was so completely incompetent? That's not a person you can give a uniform and a gun and a badge to. I don't know, but I suspect he was marginally, at best, qualified for the responsibility of that job, and the outcome shows that. So these officers in Chicago shot these 2 suspects, killed them, not going to be charged, but not because Kim Foxx wouldn't like to charge them, not like she's still not painting them as explicitly saying they created the circumstances that led to the deaths of these suspects. That's what she's saying. You want to work in that jurisdiction? You want to live in that jurisdiction and have to use force to defend yourself or your family and be subject to this prosecutor? I would recommend against it. Okay, I think, how many more do I have? I have just one more. Another Soros-funded prosecutor. Let me close that one out, open up a new one. Before I jump to the next story, I'll take a look at the super chats again. Let's see. No more of those, but let's see the law of self-defense. Any more member comments? Ryan from Eastern PA. Thank you, Ryan. Thanks for your comment. Mike, wouldn't it be more unreasonable for a law enforcement officer who presumably knows the person fleeing is a minor in possession of an illegal firearm and who has committed a crime loose on the city to menace others? Well, presumably that's part of the cop's thinking, right? This is a Chicago is supposed to be in favor of gun control because guns are killing their inner cities. So you want to get guns off the street. They do gun buybacks. They did everything in their power and failed, but did everything in their power to make it all but impossible for Chicago residents to own and possess guns, to carry guns for personal protection. They were one of the last holdouts. So on gun rights for their law-abiding, mentally sound innocents. So you'd think they'd want to get guns off the street, but they don't really want to get guns off the street. They don't really care about that. It's all just narrative. It's all just theater for these prosecutors. And any cop that's not in line with that narrative, well, he's skating on thin ice for sure. The fact that you're doing the right thing does not mean that a prosecutor like Kim Foxx won't put you in a cage with criminals for the rest of your life if she has the means to do that, and it's to her personal and political advantage. I assure you, prosecutors exist that will do precisely that. And Kim Foxx, well, if it walks like a duck and talks like a duck, I think I'll call it a duck until proven otherwise. All right. So the last story I wanted to share with all of you, we're already what, 90 minutes in, something like that. Yeah, 90 minutes in. All right. Last story to share today. And tomorrow I fly out, as I mentioned at the start. I'm speaking at the Tom and Lynn Givens Tactical Conference this weekend. So, by the way, if you are attending, unfortunately, it's sold out for those of you not already registered. So you missed it in that case. I do encourage you to go to the website. Just Google TACCON, TACCON. It's too late for this year, but I would bookmark the webpage so you're ready to sign up for next year. It's a fantastic conference. Tomorrow I fly out to for my speaking event at that tactical conference. So I may do some quick videos from the conference itself. If you are attending the conference, lucky you got there on time. If you are attending the conference, I'll be there all day Friday, all day Saturday. And if you'd like me to sign your book, you have a law of self-defense book, just bring it with you. I'll be happy to sign it. I won't have I'm not bringing any books or anything. It's not a selling kind of event. And books are hard to carry on a plane anyway. So I won't be bringing anything to buy, but if you already have a book and you'd like me to sign it and you'll be at the conference, this is me. You'll recognize me either at my class when I'm teaching or walking around. Feel free to ask. I'm happy to do that. Okay, so the last item I wanted to share was St. Louis District Attorney. So this is, it may as well be the twin sister of, well, let me see what happens if I turn off all these ads. If I lose the news story. Well, it says ad blocker is active. All right, well, that's a little better. So here the DA isn't, oh, there it goes. Never mind. Nope, all the ads are back. So much for that. So here the DA in question is another Soros-funded candidate, Kim Gardner in St. Louis. This is the prosecutor who charged the lawyer, husband and wife, who were standing outside their home facing down Antifa protesters while they were armed with an AR pattern rifle and a Walther PPK pattern pistol. They were charged with essentially, I think it was weapons endangerment. Essentially, you can think of it as an aggravated assault with a weapon charge, 2 counts, each good for 4 years by this prosecutor. She would ultimately be removed from the case by the state Supreme Court because of her egregious conduct in leveraging the case for her reelection campaign. She was, by the way, reelected. So she's the populace. The electorate has chosen her twice with the rich support of George Soros-funded PACs and various other organizations. So she was actually removed from the case. In fact, the case was completely removed from her office, given to a completely different prosecutor's office, and the charges were ultimately, the husband and wife involved, and I'm sorry, I'm blanking on their names. If anybody remembers, I feel very bad about that. These were completely innocent people. They were, I think they took pleas to misdemeanor charges, and even those then were pardoned by the governor of Missouri. So their record's completely clean. I believe the husband may be running for the Senate now in Missouri. But in any case, that's the character of this St. Louis Circuit Attorney, Kim Gardner. And here we have an event that occurred just a couple days ago where a bad guy with a gun carjacked an occupied, marked police vehicle. He pointed a gun. He took at gunpoint 2 uniformed cops in a marked police vehicle in an effort to carjack that vehicle. And prosecutor Kim Gardner has decided she is not going to bring charges against that person. So that's one way for a prosecutor to go. And folks, prosecutors have unbelievable discretion in deciding what cases to bring and what cases not, what charges to bring and what charges not. And in the old days, when prosecutors were conducting themselves in a manner consistent with justice and truth and fairness. And for the most part, the large majority of them were and are to this day. Most of the prosecutors I work with are very well-intentioned civil servants who are really seeking truth as they believe it. They can be wrong, but they're well-intentioned in their effort to apply the law fairly to the facts of the case as they believe those facts to be. But when you have these politically motivated prosecutors, like a Kim Gardner, like a Fox in Chicago, well, then don't be surprised when you get politically motivated prosecutorial decisions, both charging cases that should never be charged, like George Zimmerman, like Kyle Rittenhouse, but also not charging cases that obviously should be charged, like this attempted carjacking of 2 uniformed cops in a armed police car, a marked police car, I should say. Why is she not charging this person? She won't say, and she doesn't have to say. She's under no requirement to say. The electorate put her in office. They elected her. She responds to nobody but them. And in theory, I guess the state Supreme Court, but the state Supreme Court's not going to do anything to a prosecutor who decides not to charge. They may have problems with a poor charging decision if they think it's an injustice, but if a prosecutor decides not to charge a criminal suspect, no state Supreme Court's going to touch that. That's a political issue, not a legal issue. If you don't like that prosecutor's charging decisions, elect a different prosecutor. That's how that works. And St. Louis has elected Kim Gardner. And so these are the charging decisions you get. Now, how do you think the police feel in St. Louis? How do you think they believe this prosecutor perceives them and will treat them? If this prosecutor is unwilling to bring criminal charges against a suspect who took 2 uniformed cops at gunpoint in their marked patrol car, you think she looks at the police? You think they think she looks at the police favorably? Is likely to give them the benefit of the doubt? Considers the police part of her team? Part of a force for good in the city of St. Louis? You know, actions speak louder than words. Inaction speaks louder than words. And this inaction, this failure to charge, tells the St. Louis Police Department and all of us everything we need to know about Kim Gardner and how Kim Gardner could be expected to treat a cop or an armed citizen in a use of force event in St. Louis, Missouri. Live there, arm yourself, be prepared to defend yourself and your family at your peril in St. Louis. Okay, so that is the last news story I wanted to share with all of you today, but I did want to share one other thing, and that is that we have a series of upcoming webinars, law of self-defense webinars coming up over the course of the next few weeks. The McCloskeys, thank you in the comments. It was the McCloskeys who were charged by Gardner in that event facing down Antifa in their front yard. The Antifa who'd torn down the gate into their private community and who had burned down businesses only blocks away from this home. So the McCloskeys were well aware of the violent potential of these Antifa and Black Lives Matters mob protests. So yes, thanks for putting that in. So as I mentioned, we have a number of webinars. These are 100% free law of self-defense webinars we're conducting over the next few weeks. We're going to do, I think, 1 or 2 a week. They'll probably be an hour or 2 in length. And mostly they're kind of brief, accelerated law of self-defense. You can think of them as courses of instruction. I'll cover core elements of a claim of self-defense, particularly the 5 core elements of a claim of self-defense. I'll also do a lot of myth busting of common self-defense law myths, including, among others, myths like, let me see if I can pull up my little handy dandy list here. I don't know what the problem is with Word right now. Okay. Let me try this. All right. So some of the myths we plan to debunk in the course of these upcoming 100% free webinars, folks. I think we're going to alternate Wednesdays and Saturdays over the next few weeks. So we'll present the list of dates and times when you can attend if you like. Again, it's free. It's a couple of hours of free, not news story kind of coverage like we did today, but a coherent mini course of instruction on use of force law. Over the next few weeks. So obviously it's up to you whether or not you'd like to participate in any of those, but it's free, man. It's 100% free. You can't really lose. And if you like the kind of content we deliver normally, you'll really like this stuff because it's use of force law delivered in a less case sensitive, more generally actionable kind of way. But some of the things we'll talk about are, for example, the myth or the misconception that many people have that self-defense law is basically impossible to understand, that it's an ambiguous black box, a legal black box where a handle is cranked and the answer comes out, and it's like a Chinese fortune cookie. It's always hopeless. The answer is always, if you ask a typical firearms instructor about some self-defense scenario, or frankly, even most lawyers, the answer you get out of them is, well, it depends. What happens? What's the legal analysis in this event or that event or some other event? And they'll say, well, it depends. Folks, it's true. It depends, but it depends on actual specific legal elements. It depends in an understandable way, a way that actually makes sense. It depends on some infinite number of legal elements. It's a very well-structured framework, the American use of force law framework. And if you understand that, it's not a black box anymore. You can have a reasonable expectation for understanding how any use of force in any particular circumstance is likely to be perceived by the criminal justice system as either justified or not justified. It's knowable. You just have to have someone explain the framework to you. And that's one of the things we'll do in these mini webinars that we're holding over the next few weeks. Another myth we'll be dispelling is that, if you're involved in a use of force event, really all you can do is hire a good lawyer and have them handle all the legal complications for you. It's their job to solve the problem. And I'm sure all criminal defense attorneys appreciate that vote of confidence, but the truth is that we're largely stuck with the facts you give us. If you give us bad facts, it's going to be a tough defense. Give us good facts, and we can make you very hard to convict. And that's our goal. That's my goal. The mission of law self-defense is to educate and inform you on use of force law, that so heaven forbid you're compelled to use force to defend yourself or your family, you do so in such a way that you end up giving your attorney good facts and make yourself hard to convict. In fact, these webinars I'm talking about, we're calling them, they're titled the Hard to Convict webinars. So that's what you should be looking for. We also have another myth we'll be debunking, and that is this. We've all heard the adage, right? Better to be judged by 12 than carried by 6. And folks, I call that a myth because it's a lie. It's an utterly false choice. Its premise is that you have to pick one or the other. You have to decide between being judged by 12 or carried by 6. You're either going to die or you have to leave yourself vulnerable to conviction. And that's not the true choice. The true choice is you can effectively defend yourself against life-threatening attack and still be hard as heck to convict. And that's our goal, to transform you, all of you in the law of self-defense community, from being people vulnerable to conviction by a rogue prosecutor for having defended yourself or your family, to people who are so hard to convict that, frankly, it's not worth the effort by a prosecutor. That's where you want to be. Because if that's where you are, you're not even charged, much less prosecuted. So that's our overarching mission. And then a fourth myth will address is that you need to be a lawyer or have a lawyer or pay a lawyer a ton of money to understand self-defense law, all that legalese, those statutes, those court decisions, those jury instructions. And sure, if you just go look up the statutes, court decisions, and jury instructions, they are legalese. They are hard to understand, and they don't necessarily mean what they seem to mean. And if you are a lawyer or you pay a lawyer a ton of money, he can explain all that to you. But there's a better way than going to law school or paying somebody a lot of money, and that's, well, come to our Hard to Convict webinar, because we'll explain much of this to you in plain English. That's what I bring to the table, folks. I don't make the law. I'm not a legislature. I don't have a magic wand that just acquits people when I wave it around the courtroom. My value added to all of this is to translate the legalese of our actual use of force law, not the internet use of force law, not what your cop neighbor told you would be lawful, not what the lawyer who did your house closing told you over cocktails. The actual law of self-defense. I translate the legalese of the actual law of self-defense into plain English, so it's understandable and, as important, actionable for you in the moment of crisis, so that at the end of all that, after you've won the physical fight, which is always the top priority, you have to win that physical fight. But after you've done that, you're also well positioned to win the legal fight. So if that is of interest, if a webinar, a 100% free, hard to convict webinar is of interest, then I urge you to sign up for one of them. Unfortunately, I just looked at the URL that was supposed to be for this, and it's apparently not set up yet. You're watching this video, you see my little title here in the image of me. It says lawselfdefense.com/webinar. That's the link you'll want to use to sign up for the webinars. Now, these webinars are 100% free, folks. We don't charge a penny for them, but we are limiting attendance to no more than 100 people per webinar, and that's because we have a very substantive Q&A component to those, and too many people, and I can't answer all the questions, which is what I'm trying to commit to for these. So I promise you, I mean, we have hundreds of people on this YouTube video alone. I can assure you we will sell out. They're free. We're not charging. But every seat for every one of these webinars will go. For every webinar, there'll be 100 seat, and every single one of those will go. That's why we're having people registered beforehand. I see someone asking if they can get CLE for this webinar. The answer is we're not going to pre-accredit these for CLE. It's too much effort, folks. I'm sorry. I've done CLE in 35 or 40 states, and it's a painstaking process under the best of circumstances. It's a little different in every state, and that makes it even worse. And when it comes to online content, it's 100 times more complicated. They make it, the Bar Association makes it more complicated. But there are many jurisdictions, many bars that allow lawyers to self-report for CLE. So if that's of interest, I certainly encourage you to do that for your time. So what you'll want to do is, I guess not today because it's not up yet, but it's supposed to be up no later than Friday. The registration page, again, they're 100% free. The registration page for the hard to convict webinars running over the course, a couple of weeks over the course of the next few weeks. Keep that URL in mind. Check it out on Friday, and you'll be able to sign up. Once they're full, though, they're full. So something to keep in mind. All right, folks, that's all the substantive content I had for all of you today. Let me take a quick look at the super chats again. Make sure I've answered all those questions. William White, thank you for the super chat. That's much appreciated. And he writes, just joined CCW Safe, used your code, thanks. Well, I think that was the right call to make if you think they're the best fit for you. And frankly, I think CCW Safe will be the best fit for most people. I can't say it with 100% because, people's circumstances vary. How much money they have to spend varies. What they have at risk varies. Their life circumstances vary. So I can't say that 100% of people CCW Safe is the right fit, but I expect it's the right fit for a large majority of people. So glad to see you get that level of protection, William. And JPC, thank you for your super chat. Writes, always enjoy your videos. Well, I really appreciate that as well. So thanks to all of you who've, again, invested almost 2 hours of your valuable time to spend it with me, Attorney Andrew Branca at Law Self-Defense. I can't tell you how much I appreciate it, how humbling it is. And thank you. Thank you for... I appreciate all of you. I can't tell you how much. All right, folks, I'm going to wrap up at this point. Until next time, please remember, if you carry a gun so that you're hard to kill, then I strongly, strongly urge you to also make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law Self-Defense. Stay safe. And let's try that. Take 2. I'm Andrew Branca for Law Self-Defense. Stay safe.